When it comes to inalienable rights and laws for protection of persons and properties, Texas is a very difficult, sorry state for folks who believe in same-sex unions and marriage. Iowa, Massachusetts, Connecticut, New Hampshire, Maine, Vermont have legalized marriages. A number of other states have legalized civil unions. Some states recognize one or not the other. Some you can enforce, some of the other. Texas doesn't recognize the union at all. It is a ambiguous, unfair, distorted conundrum for gay and lesbian folks who want to have a life like everybody else under the laws of the United States of America. Till the Supreme Court rules, you really have very difficult remedies compared to everybody else because of the policies of the state of Texas. Full faith and credit is applied to judgments, but if you were married in Vermont and you moved to Texas and you want to get a divorce like any other couple, full faith and credit at this point has been denied by the Supreme Court of the state of Texas because it violates a policy of Texas. Now, if you spend an extra $1,000 and got a judgment of some kind regarding your marriage, that is in some events enforceable in the state of Texas, which makes no sense at all, generally. But there are some very poor, bad, but better than nothing remedies for folks in this tough situation. You can file for a dissolution of partnership, you can file for injunctive relief, and you can at least segregate your assets under Texas law using the fiction of a partnership. It's complicated further because under some exceptions to the family code, 2 men or 2 women can adopt a child. But now, you can have 2 moms or 2 dads, and if there's some kind of dissolution of that relationship, you do have the right to go in and file a suit affecting the parent-child relationship in that situation and deal with issues such as child support, access and possession. But it is too little and it's too late, and it's less than what we should have in this state, so under the equal protection of laws. All of this legal hoop jumping that we have to do really creates a terrible situation for the children. Texas does not even recognize, a duty of best interest to the children if they're not of a man and a woman in a marriage. Children practically have no legal rights from such relationships in the state of Texas. Another option for folks that are not already married is to enter into a partnership agreement and structure it around the terms of a prenuptial agreement to at least set up some legal rights between gay or lesbian folks who want to be sure they have some format, some platform for a orderly distribution of their assets if the point comes where they want to depart and not be together as a married couple, whether Texas recognizes it or not. It would behoove you to speak to an attorney and at least set up those perimeters for dissolution of your relationship as legally and as enforceable as you can. So you will at least have some order rather than the existing anarchy that Texas provides you. Cohabitation and domestic agreements, though a far cry from what your rights should be, are pretty lenient, pretty broad, and cover most of the areas, other than the areas of children, that you would have an opportunity to participate in if there was a more liberal and realistic policy in this state.
Nacol Law Firm, may I help you?